when you talk about a high degree of autonomy in Hong Kong, the first thing to note is that it is not absolute autonomy, right? In which case, then Beijing will be a symbolic figurehead for Hong Kong, and Hong Kong will be like independent, like Australia, where the Queen regains control through the Governor General, technically, and has dissolved Parliament once, but very, very rarely. Okay, so it's really a rubber stamp, right? A sovereign symbol. But Hong Kong, that's not true. I mean, first you have to deal with what is the autonomy for Hong Kong. Number one, there are areas which are not competent for there to be autonomy. For example, defense. How can one part of China deal with the defense of the whole country and enter into alliances with other countries? Forget it. Defense is not a regional thing. It's a national thing. Foreign affairs, of course, nobody will accept Hong Kong with an embassy. All right. So these are non-autonomy issues. All right. So apart from these two, a lot of people have a misunderstanding. They think it's, apart from these two, then Hong Kong is full autonomy. No, it's not right. These two areas have nothing to do with autonomy. So when you talk about autonomy, the running of Hong Kong, in that you have a high degree. So what does that mean? It basically means that at least for the first 50 years, you have to adhere to the basic policies, which is what? Which is defining the relationship between the central government and Hong Kong. It's in a way a self-imposed restriction. If you look at the Joint Declaration of Basic Law, it's basically the building blocks of Hong Kong society in 1984. What in Article 5 of the Basic Law is called the original capitalist system or the previous capitalist system. Why? Because China wants to be so sincere, they want no argument. You want the capitalist system previously enforced, it will continue for at least 50 years. But in order for there to be no argument, let's take a picture of this system. It's not because capitalist system changes everywhere. In Scandinavia, it's very different. It's more like a social democracy, right? So let's have the previous. Let's not argue the one you're used to, right? The previous capitalist system. Okay, so they take a picture. For example, common law, basic policy. So what they did is they take all the systems of government and did a basic policy on each. About 17 basic policies, like the tax. You can't have high tax. It has to be free port. You can't have socialism. Even if 7 million people in Hong Kong say, we want socialism, right? It's a democracy that we want socialism. No, you can't. Because that was a certainty of China's dealing with Hong Kong. So basically, like the right of abode, one of the first things that British government discussed with the Chinese government before the handover is the right of abode. Because what they're worried about is that if the legislation on immigration continues past the handover, i.e. during colonial days, British citizens can just walk into Hong Kong. When you realize that it is the legal system that's important, then you must look to keep the character of that system. Now, what is the character of the common law? The word common. That is not something only peculiar to one place. The common law is a body of jurisprudence common to all common law jurisdictions. Right? Your judgment may not be binding, but we look at it by reference, so it affects everybody. Largely, it's a very similar jurisprudence, the common law. It's a common law family. All right? So when you deal with national security, it is very wrong to say, on the one hand, we must have the common law system. So even if China is a unitary system, but because of one country, two systems, you do something very unusual compared to the rest of the world. You let our regional courts, the SAR regional courts, and the police deal with this situation, bring it to court, right? And our judges to deal with it. But it would be very dangerous to say, but on the other hand, we don't want to follow common law arrangements in all common law countries on how national security courts or judges deal with national security cases. That's dangerous to say, oh no, although it's been said that although a lot of, if not all common law countries have a special court to deal with surveillance, to deal with espionage and national secrets, and also the judges go through a more stringent vetting. So it's not just your competence or experience, but security vetting. which you can imagine. I mean, are there any weaknesses of that person that might endanger national security? Because you have to tell him, even if it's behind closed doors in camera, you have to tell him how the whole thing works. So you have to trust him, right? So it's the same. It's a very logical thing for all countries, America, England, right? So, and therefore, it comes to the question of, let's not confuse the question of whether you should have judges in Hong Kong who are not Chinese nationals, or who may not even be permanent residents in Hong Kong, dealing with such cases. It should not be confused. The rule in all common law countries, Hong Kong's an exception, is that it's always the nationals of that country who sit as judges. Okay? And not only that, but they also live in that country. Why? Because there's one very fundamental principle, is the law applies to everybody, especially the judges who interpret the law. Right? It applies to you too. You're not above the law. Right? That's the first point. The second point is that in other common law cases, you can share expertise. Right? You talk about civil law, contract, intellectual property, all right? But when you come to national security, it's very different, because you are dealing with not common security. You're dealing with national security. Okay, to give you an example, if a judge in Hong Kong is an expat, and let's say he has a British passport only, but he's a Hong Kong permanent resident, but not a Chinese national, so he doesn't have 3 stars, but he's a Hong Kong permanent resident. Let's say he is to do a case on national security, and the case involves a British person being accused of being a spy for the British government. There will be a clear conflict of interest. It does arise, because being a British citizen, he must be loyal to the British government and the British people and British interests. But the case is a clear conflict. You're dealing with a person which is offending Hong Kong's law but serving British interests. Clear conflict, right? So I think the approach we should be looking for is this, that when we deal with national security cases, we should follow the universal norm in common law, leading common law jurisdictions. Let's follow an example. The worst thing is to say, oh, on this thing we don't follow the common law example, the universal norm, because with a norm you can compare. If you say it doesn't apply, then it may not get better, it can even be worse. But that's very dangerous. I'd rather have a norm that you look at, all right? And then you have to deal with the question in a very practical way. Don't deal with the CFA judge. It's very different. That's just the CFA. It is, I think, just to remind you, I think it is Article 82 of the Basic Law, which says that the power of final adjudication of the Hong Kong SAR shall be vested in the Court of Final Appeal of the region, which may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. That only applies to the Court of Final Appeal, right? Which is important because it's the final word on jurisprudence in the common law world of Hong Kong. Okay, not to be mixed up with expat judges. Okay, so these judges, they don't have obviously Chinese nationality. They're from Australia, Canada. They can even invite America, anybody from common law jurisdiction who can help on a particular subject. They don't even have to live here. It's a very exception to the rule. The law doesn't really apply to them because they are not a national here, nor do they live here. They just come in here just to give you some help on that case. They go. So therefore, that's a very different situation when it comes to national security, right? Because that is something, the word is national security. A lot of expat judges may make Hong Kong their home, but they haven't made China their country. And so how can they deal with China's national security legislation? right? Because if that is the case, then you might as well have the court situation, send it abroad. Right? Let's say Privy Council, let's send it abroad. They're nothing to do with sovereignty anymore. But if you talk about national security legislation, therefore there must be an actual, if not perceived, conflict of interest if the person who deals with those cases, not only does he not have Chinese nationality, he only has a foreign passport. And he is therefore obliged to have his allegiance to that country of which he's a citizen, right, in what he does. And what happens if he's not even a resident here? So a case is stronger to keep our expat judges helping us here, because at least they make them their home, irrespective of how many passports they hold. So the question is, what connection do they have in Hong Kong? At least to give them some credibility to deal with a case that concerns the national security of the whole country. At least you can speak because you are connected to Hong Kong. Right? So therefore, it is a subject that we need to see very clearly and also draw from common law experience how you deal with it in other countries. And it's very dangerous to try and reinvent the wheel because it might not come out being round.